She's like a veteran at this point.
I know. I don't even know why she asked. Right?
I mean,
Because she has to.
permission to practice for myself too, Your Honor. That's
That one would be denied. You know that.
fair enough. Then I'll come
All
back
right.
to
What are we doing on this?
I'm just jumping in the case, Your Honor. I'm asking for an adjournment to
Maybe approach.
Oh boy. It's Monday. I have 2 cases. Really?
Ian already said it's the short dockets that take the longest. Okay, hold on, I have to stop.
She's slow.
I didn't
I know. Because he just started walking.
Right.
Good.
Yes, sir.
All right. Recall the case of People versus George White.
That was it, on behalf of the people.
Sam Bernstein again for Mr. White, Your Honor.
Reference, before I passed the case, we had a bench conference about some phone calls that were made, and I let you talk to your client. Also, that there at least was an indication that the defendant may have been within 1/2 mile of the excluded zone. We called over to community corrections. They've indicated that there is no violations at this point, so I'm not going to deal with that. But
I can address the phone calls if the court would like.
yes, please.
There is something of a story, and we're not going to litigate the probate stuff matters, but so there's been a very stressful situation going on with George White's mother being sick in the hospital. Apparently, he has like an alternate medical power of attorney. The complaint he does, yes.
Okay.
Or medical power of attorney. I don't know how to phrase it. Okay. Oh, let me just go first and we'll see.
He's got the medical power.
Yes.
Okay.
But I think the victim might also have like a medical power of attorney or a claimed medical power of attorney. And so he said that he was like signing paperwork for like an immediate surgery, and then he was like stopped in the middle of signing it. And they said that the other person, the victim, was like wanting something different for the mother. And so he says that he gave his phone to a nurse who made the calls to the victim, that he did not call her. And that when he learned that she was there, he later went into like another section of the hospital to like stay far away from the situation.
So you're saying, just so that I'm clear, all 6 of the calls were from that?
Yes, he says they were made like back to back to back.
That was on the 4th.
Right.
But what about the 2nd?
I don't know about this. No, I don't know. But he says, he told me he has no wish to speak with her at all, that he hasn't spoken with her, and that he doesn't want to go near her or have anything to do with her whatsoever. So he definitely doesn't, it wasn't like a don't show up to court kind of situation. He just doesn't want to have contact with her whatsoever. It seems like there may be some sort of like kind of probate-ish issue with like medical powers of attorney and who may or may not have power or something, but the appropriate forum to litigate that wouldn't be, I don't think it would be Judge Simpson. It would be another forum, and that's not really for today, I would suggest. But I think that's sort of like the backdrop of what happened here. But I mean, either way, I mean, he's not supposed to have any contact with her. And I think he knows that, and he doesn't wish to speak with her on any basis.
Lucinda.
I'll let you talk.
One of the calls was on March 2nd, and then on the 4th, one of the calls that was made was 2 hours before the back-to-back calls that were supposedly from the nurse. We would be concerned with the contact with the victim.
I won't stop you from talking if you want to contact.
First and foremost, she gave a dep while I was in jail.
She what?
A dep, one of the deps in jail. I was in the tank right there. I hadn't been arraigned yet. Gave him her number to give to me. Never contacted her. I don't want to. She's a devil. She's evil, like my mom. Okay, look. But anyways, the situation at the hospital was when she got transported from Dearborn to
She
Royal.
being who?
My mother, and I was there with her. She vomited 4 buckets of blood. She was going to die right there. But they got her to Royal to get
Okay,
stuff.
sir.
now during that exact moment.
The judges told you.
Okay, I'm sorry.
I agree, Mr. Bernstein, that I'm not gonna sit here try to litigate the probate matter in terms of a power of attorney, but the victim's relationship to the defendant is what?
Ex-wife. See, that moment.
No, but we can't interrupt the court.
Was the power of attorney granted after your divorce?
The power of attorney was verbally given in Dearborn and fraudulently taken.
Can you just answer my question
Sorry, yes, it was verbally, yes.
before the divorce?
Well, there was no power of attorney before we've been divorced for a year and a half. It was given to me at Dearborn.
So, no, it wasn't.
Oh, no. Thank you, Mr. Jeez, oh, mate. All right. Well, without doing more checking, I don't know that I can figure out these phone calls. I understand what you're saying, Miss. And I don't want the victim contacted from your phone at all, ever. Am I clear?
Yeah, no problem.
What part of Carpenter Road do you live on?
I live on, actually, it's right there.
What are your cross streets?
I'm right in the middle between Washtenaw and Packard.
The block that I'm creating, which is the exclusion zone, is east of Carpenter, south of Washtenaw, west of Gulfside, north of Ellsworth. So that we're clear, sir, you're gonna have to stay on that west side of Carpenter Road. You're not to travel on the eastbound Carpenter at all. So if you gotta go around the block to get to your place, you're just gonna have to go around the block. Am I clear? Is that a yes?
Yes, I'm trying to picture it in my head.
What are you trying to picture in your head?
So like you say, crossing Carpenter, what about? And then it hits Washtenaw. So are you talking about that corner right there would be like exclusion, or does that also cross over to the other side of Washtenaw?
I can picture it in my mind. I'll show you on the Google Maps afterwards.
Thank you.
It's like a block. I get it.
Well, I just don't want to get it wrong. Just get it wrong.
You know, the gas station that's on the corner of Washtenaw and Carpenter.
Yeah, there's two of them right close here.
You can go on Washtenaw at that gas station, either direction, but you can't go south of Washtenaw. So you know Washtenaw down the Gulf side? You can't go south. You can't go into that area.
Okay.
On Gulf side, you can't go east or west. And then Ellsworth, where Meyer is, that includes that block. Mr. Bernstein will show it to you, I'm sure.
I have it right here.
We'll have it all laid out. You got it?
Yeah.
Yes. Thank
That's Carpenter. That block, you cannot go in that block. Okay,
Okay.
so he's saying if there's stores along there that you like to go to, you're gonna have to go to different stores.
What if they're on my side?
Your side, fine.
Okay.
You can't go to any of those places between those streets, okay?
You can go to Kroger, Home Depot, and Lowe's.
So like there's a gas station there and there. I
Can't go to Meyer.
But I can go to that
You can go
Can't
to,
go to Target.
one on like towards this jail on the side of the road.
no, you can't go to Hobby Lobby either, George, okay?
No, no, I go.
You can go to that gas station. You cannot go to that gas station, okay? I'm gonna email you.
In that block.
Yes,
I just want to be clear.
it's crystal. It's crystal clear, Your Honor. Crystal clear.
Thank you. I've signed the order.
Okay.
Creating that exclusion zone. And then we need to adjourn this out. We almost were here long enough to get to that date.
Right.
What's their name? Sure.
Good afternoon, Your Honor. Alexander, on behalf of the people seeking permission to practice pursuant to Michigan for Rule 8.120 under the supervision of Assistant Prosecuting Attorney Morgan Barosa.
Permission to practice is granted.
Bridget Coons on behalf of Mr. Vasher.
All right. Your name, sir?
Thomas Vasher, Your Honor.
Thank you. All right. And what are we doing?
We were originally going to set this from final settlement conference. It's my understanding, though, that the prosecution plans on increasing this to a felony charge.
And that is correct, Your Honor. We were going to reauthorize this as a felony strangulation. That's in the police report.
Okay. And so when were you intending on doing that?
Your Honor, we were going to do that this afternoon. There was an offer and it was to plead as charged. And then the new case wouldn't be authorized.
Got it. Okay, so you're gonna authorize a felony and ultimately dismiss this.
That's correct, Your Honor.
Well, if it's authorized today, I'd like to get him on the PCC docket as soon as possible since he's in custody. I mean, he might remain in custody, but you want to get that one moving as quickly as possible.
Assistant Prosecuting Attorney Morgan Barosa on behalf of the people. I do just want to note that he does have multiple circuit court matters on all of which his bond is denied, and those aren't set until April 4th. So he's going to be in
Regardless. Okay, got it.
Until
That's not to say that we're going to delay and
No, I understand.
You to know.
I understand. All right, when's my next date on this docket?
April 1st at 1 p.m.
So I'll adjourn this matter then to April 1st, 2024 at 1 p.m. And then hopefully what's today, the 18th, if that gets authorized. He actually may see me before then on the PCC docket.
can I get a chance to speak?
If you'd like.
If at all possible, can I get a low bond in case I can make bond?
Well,
I'm going through a situation where if you can't see, I'm terminally ill, so I don't know how much longer I have. I got life that I'm trying to spend a little bit of time with my son. This case here, not worried about it, nor am I worried about none of my cases because no one's coming. There's no wrong been done.
hold on.
That's
Hold
fine.
on. I don't want you to say anything about the case.
I'm not.
Okay.
Uh,
Here's what I'll do. How many other, but
all of them.
those other cases, he wouldn't get out in any respect because bond's denied. They're not going to hear it till the 4th, which would likely be the earliest time at which they do it. So what I'm going to do in this case is I'm going to leave your bond where it is in this case. Let the felony authorization take place, see what happens on the 4th, and then see what we can do regarding that.
I actually go for what is it where you go and ask for a bond reduction again on the 21st when I go see for my other case
On the 21st,
on the 21st. I have
hold on a second.
Your Honor, he has an malicious destruction of police property, a controlled substance, an R&O, another controlled substance, and another malicious destruction of police property, all of which bond are denied, all of which are set for the 4th. But there's also a hold out of Van Buren.
The bonds
which
were not
looks
denied.
Like the bond is denied as well.
the bonds were not denied in none of the R&Os.
So you don't see anything set for the
No.
21st?
The only date that is not the 4th, there is one in 14B that's a contempt of court set for the 21st.
Okay,
But that's 14B.
B's case, got it. So,
Everything else is circuit court.
all right,
But I'm on the whole, I should be here until the 14th because that's when I'm scheduled for the reentry into the program. But if at all possible,
The 14th of what?
the next month, but my sister's trying to make it to where she can pay the 30,000 on my bond to get me home, and they've already went in.
Okay, if they paid the
They're the
30,
ones who set up the
right,
hearing for me on the 21st. So.
all right, but if they pay the 30,000 on this case, you're still held on, and even if you resolve and somehow get out or have a bond on the 14B matter, you still have the bonds denied, which aren't going to be addressed until the 4th of April.
Okay.
So given what's happening in this case, given all of that, I'm going to continue this bond as is. So the bond will continue in this matter. Thank you.
Thank you.
Thank you, Your Honor.
You too.
Good morning, Your Honor. Deborah Schlossel, defendant, Mr. Adrian Lottie, Dr. Adrian Lottie, who is approaching. Your Honor, to take the date and time set for sentencing. Dr. Lottie and I are in receipt of the pre-sentence report. We have no additions, deletions, or corrections. Your Honor, Dr. Lottie has no criminal record until this case. He's about to be 77 years old. He cares for his mother, who's about to turn 104. On the night in question, we know this is not an excuse, but his mother had been hospitalized and he got a call from the hospital that something was wrong, and he immediately went to the hospital. When he had drank alcohol that night, when he drank alcohol, he did not expect to be going anywhere. He knows that he should have called a friend or called Uber, but this was his mother, who's very old, and that he was taking care of, and just rushed there to attend to her and see what was going on. He's sorry that he did that. Your Honor, he has a very impressive life. He's been very active in the civil rights movement. He's also a college professor. He teaches civil rights law, and he was very active in several organizations in the city of Detroit with regard to civil rights over decades. Your Honor, he's got a CV that's over 20 pages long. He does a tremendous amount of community service and educating the community. He also is a real estate agent and an expert witness in trials and other legal matters. Your Honor, because he cares for his mother, she often gets up at 2 or 3 in the morning in the middle of the night. And so testing on the SoberLink has been difficult for him because he had a stroke a few years ago and he's required to get a certain amount of hours of sleep because not enough sleep causes high blood pressure, and that's why he had his stroke. Your Honor, so we are asking, even though it says to continue with the SoberLink for 30 days, he has been compliant with the SoberLink. He hasn't had a single incident, and it's been many months that he's been on it. We're asking that you consider either doing away with it or that you consider lessening the amount of testing. He says that the most difficult time to wake up to test is the one at 6 in the morning because he is up in the middle of the night caring for his mother, and then he tries to go to sleep. So if Your Honor would consider maybe cutting the amount of testing or giving him a later testing time, we would appreciate it. I think he's currently testing 3 times, so we would ask for 2. Your Honor, also, we would ask possibly if there could be less than a 9-month probation term. I mean, he's almost 77, never had an incident until this. It's an aberration. It's not who he is. And as you know, the presumption is against probation for a case like for first-time OWIs. And we would ask that you also possibly consider no probation. Your Honor, he would like to say something to the court.
Doctor, what would you like to tell the court?
Just that I'm very sorry and remorseful about all the trouble I caused to all the people involved in this. And when I took the victim impact course, I had already had some sense of the trouble that drinking and driving causes. but I hadn't really internalized it as much as I did after seeing the class. That made me kind of realize it more. I have myself been victim of drunk driving, but I never got hurt. I just got car damage, sometimes pretty badly, but it still didn't give me the same sense that that video gave me. When I took that course, that gave me a much stronger sense of just what it does to people physically and psychologically. So I'm very remorseful about that. Excuse me.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from a non-probationary sentence. Particularly, the alcohol screening and assessment identifies the benefit of an early intervention program and abstinence from all intoxicants. Probation, the court will then follow the recommendation of probation for probationary supervision with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'll place you on probation for a period of 9 months. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $270 probation oversight fee. When can you pay that?
Your Honor, can you have a payment plan?
Does he have anything today?
Oh, yes.
What can you pay today? Tell the judge.
I don't know. How much is that altogether?
Give me a total.
13.25.
Half, okay. One half today. And then the balance is arranged by probation on a payment plan.
Thank you, Your Honor.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete an alcohol awareness program and to do that within the next 60 days. You're to provide proof of the victim's impact panel attendance to probation. You've completed that. With regard to the sober link will continue for a period of 30 days in lieu of the 4 days in jail. I'm not going to reduce the testing. It's the program that I have in place. I'm doing that in lieu of what would be part of my sentence, which might be 4 days in jail. So I'm giving him that as an alternative to it.
Thank you.
I'll order 93 days in jail, credit 1, the balance is suspended. Thank you.
Thank you, Your Honor.
All right. My understanding there's a motion.
That's correct, Your Honor.
Go ahead.
Yes, Your Honor. I had filed a motion to ask the court to consider allowing Mr. Petitprin to withdraw his plea. The basis for the request is that his plea was not made knowing or voluntary in the sense that he did not have all of the information that he would need to have to make the plea relative to his discovery. He indicated to me after our first meeting that he had never seen his police report. I was able to get it from the Ms. Hightower, as I had just been appointed on the case to review it with him. He didn't know that some of the information he contemplated being present was actually, in fact, addressed in the police report, and he would have considered taking his case to trial had he known that. He also had never seen the video footage from the dash cam or body cam that was available to him, and has asked that the court consider that in the interest of justice as well, allowing him to withdraw his plea so that he can make an informed decision moving forward as to how to proceed. I had discussed this with the prosecution in hopes of maybe trying to resolve the case in an alternative way, and we could stipulate to the withdrawal of the plea. There was some discussions as to potential other settlements, but at this time, we've not reached an agreement on that, and we're just waiting on the court to issue a decision.
Okay, based upon what I have in front of me, there was a request either for an evidentiary hearing on that. I don't know if that is still the request. If he's saying he didn't see the information, this defendant had been before the court on numerous occasions. Adjourning everything out so that the defendant could indeed review the materials and other things regarding this case. I am having a hard time believing that he didn't have that information from counsel or otherwise have requested that information and or refused it.
Yeah.
No, thank you though.
To talk to you.
To me?
Yeah.
Oh, hold on. So, what he's explained to me is that he requested this many times and was, granted adjournments to be allowed to review, but he had never reviewed it. So that's the position that he's maintained. If the court is inclined to schedule an evidentiary hearing on that issue, I understand and I'll explain that to Mr. Pettifrin.
All right, because my inclination would be to deny his motion. I mean, I find it hard to believe that this matter had been pending since May of 2023. He enters his plea on October 4th, but that's of course after he's been out on bench warrant status. And then he's going to indicate that in essence, he knew nothing about the case or what was contained in the report prior to entry of his plea. I'm having a very difficult time believing that. So I will need his previous counsel to indicate what has happened on that. So I'll set an evidentiary hearing. I'll set that hearing for April 10th, 2024 at 3 p.m.
And Your Honor, will that be in person or by Zoom?
in person.
Thank you.
And you'll need to subpoena counsel, previous counsel here.
Thank you, Your Honor.
You're welcome.